Next, we will look at some potential outcomes that result from various court actions. One possible outcome is that you and the other party may come to an agreement on how your case should be decided. When both parties come to a written agreement and there are no contested issues to settle, the court may issue a summary decree, which means that your petition may be granted without a final hearing or any further courtroom proceedings. If possible and obtainable between you and the other party, such decrees can save both you and the court a tremendous amount of time and expense. When seeking a summary decree on a divorce, you must still wait until 60 days have elapsed from the date of the initial petition before the decree can take effect. You must also submit to the court written pleadings that detail the specific agreements between you and the other party. The first written pleading we'll examine is known as a verified waiver of final hearing. This is a relatively brief document signed by both parties under oath. This pleading tells the court that each party agrees to give up their right to a final hearing. The pleading also lets the court know that both parties have reached an agreement on all issues and that you both agree you don't need the courts to hear evidence and make a decision on such issues as child support, parenting time, or property settlement. Along with your verified waiver of final hearing, you must submit a settlement agreement and decree of dissolution of marriage. Submitting these documents allows the court to grant a ruling without a final hearing or other courtroom proceeding. In order to obtain this decree, both parties must sign under oath all documentation. The forms for the settlement agreement and decree of dissolution of marriage are available on the Indiana Supreme Court self-help website. If children are involved in the relationship, whether by birth, by adoption, or by legal determination of paternity, then the decree must include an agreement pertaining to child custody, support, and parenting time. As mentioned in Chapter 11 of this video, the Indiana Supreme Court provides an online child support calculator to help you accurately calculate how much child support you or the other party must pay. This step-by-step guide can be found online at the web address shown on your screen. It will automatically generate the child support worksheet that you are required to submit to the court. You must provide the court with a copy of the child support worksheet in order for the judge to finalize your divorce. Another word about child support and parenting time. You and the other party may agree to deviate from standard worksheet guidelines for child support or for parenting time. However, if you do, you must supply the court with a valid reason in writing for your deviation. Both parties must agree to this deviation, verified by signatures under oath at the end of the settlement agreement. If both parties have a signed, notarized agreement in a paternity action, the court may approve your agreement without a final hearing, as long as the agreement specifies custody of the children, parenting time, and child support figures gathered from the Indiana Child Support Calculator. Step-by-step guidelines are available online by using the child support calculator listed on your screen. When preparing your paperwork for the court, be sure to include copies of any online calculations and copies of any paperwork supplied by a mediator.